Welcome back to Artificial Antics, where Rico and Mike will talk about the implications and opportunities around artificial intelligence, machine learning, and deep learning. On this episode, Mike talks to Vincent Allen about protecting your creations in the AI era, covering prompt best practices, real hallucination horror stories, and must-know patent strategies. Tune in to stay creative without courting legal trouble.
Hey everyone, this is Mike from Artificial Antics. We've got our first show in a while here. I'm joined by Vincent Allen, who is an intellectual property attorney and who's been getting really into the AI technology space. As you know, you can imagine, there's lots of interesting stuff to talk about there. So without further ado, I'd love to introduce Vincent. Yeah, Vincent, so how you doing today?
I'm doing great. How are you, Mike?
I'm doing great. Like I was saying, it's a sunny day outside. It's Friday, and looking forward to relaxing with the family this weekend.
You and me both.
So Vincent, maybe as a starting point, why don't you go ahead and introduce yourself, introduce your firm, give the listeners a little bit of color and background on you, and especially I'd love to hear about your AI journey, right? So kind of how all this came to be and why we're talking today.
Sure, no problem. Well, I'm a managing partner now at a intellectual property and technology law firm called Karstens, Allen and Gorley, and we're up in the Dallas area, north of Dallas, in Plano is our office now. We've been in this area over 25 years, and in fact, I have been with the firm about that long as well. I started out right out of high school. I loved aviation. You can see I've got the airplane in the background there. And so I went to aircraft maintenance school and thought I was going to be an A&P technician, but ultimately fell in love with the electrical classes that I was taking and decided to go on to electrical engineering. And so I did that, and in the process of getting ready to graduate, one of my professors said, you know what, instead of going to work, you ought to come get your master's in electrical engineering, and you can work on this project that I have going, be my graduate assistant. And I said, well, let me think about that. I never really thought about, continuing my education beyond undergrad. I was just going to go to work. So I stumbled across patent law when I was doing some research online, and there was a big demand for electrical engineers to go into patent law. And the more I read about it, the more I felt like that would be a good opportunity for me. And so ultimately, I applied to law school. I went to Baylor Law in Waco, and then ended up here in Dallas and have been here ever since. During the course of my career, I've done a lot of patent and trademark filings, including both the procurement of the intellectual property as well as litigating patent and trademark disputes that might arise. And during that time, I've even, occasionally would address artificial intelligence in the patent applications. It's not a new technology. It's been around for a long time. But it didn't become super popular until the large language model came out, ChatGPT in particular, back in November of 2022. And at that time, I started playing around with ChatGPT, and I realized it was going to be pretty revolutionary. And I said I needed to understand, how it works and come up to speed on some of the legal issues that might be present. And one of the things that I identified pretty early on was the problem with putting in confidential information into your prompts or using it in order to generate a result from ChatGPT. And the problem is that the model can be trained on the prompts that are put in. And so you risk exposing your confidential information if you put it in with the original ChatGPT. Now there's some, if you get an enterprise version, or if you have click a button, you can try to avoid the use of your data for training. But that was a risk that I identified. And so I said, I'm going to start doing some talks about, the potential risk associated with using Gen AI. And I started that in early 2023, gave a couple of presentations. And then I was getting ready for one presentation with the Plano Chamber of Commerce on the state of AI. Included some speakers from, Microsoft and Google as well, talking about their technology. And of course, I'm kind of the naysayer, not a
Yeah,
naysayer, but
yeah,
I'm kind of the guy that has to rain on people's parades and say, look, you got to be careful about what you're doing.
right.
Um, and so anyway, I did that, and also I met with a gentleman named Rob Taylor before the event, and I found out he had been vetting many use cases already for Gen AI. And so we decided to partner up, and he joined our firm. We started up what we're calling the AI Triage Center, and that's what we use to describe, all the services that we provide related to Gen AI, from the initial development of the software or the products that you might be implementing to developing agreements, consent forms, etc., that you might need with the application of Gen AI. And then also protecting the IP associated with it. So if you need to file a patent application on the technology that you have developed, even if it might be based on a working model, I mean, somebody else's model, like
Right.
OpenAI's model, you can still get patent protection on the way that you're using it. And so we advise clients in that area and help them secure intellectual property, as well as stay out of hot water, when it comes to the compliance issues.
Yeah, no, that's great. All really important stuff. One of the things that I was thinking about with you mentioned agreements, right? And different things. And I said, gosh, so here's one that I don't even think I have on the list of things to ask you about, but I think might be interesting is a lot of people these days, I think, are using tools like ChatGPT and other LLMs to generate their operating agreements and a bunch of other stuff. Have you any stories on either side where you've seen a big benefit or a big downside, or let's say big issues with that? Like any kind of thoughts on that?
Well, you say operating agreement. I mean, that's a legal document in my world.
It
An
is.
operating agreement to govern how a LLC might be run. So I think you need to be really careful. In fact, I'm telling you not to use, uh, Chat GPT or other LLM to create legal documents. Now, that doesn't mean you can't ask it questions and try to, get the answer to certain things. But I think it's really important to also consult a lawyer in that
Yeah.
area and make sure you're doing it right. Even if you come up with a first draft of the agreement, there's
Yeah.
chances are you've missed something, or Chat GPT missed something. And so if you're not careful, you can really get yourself in hot water using it for legal agreements. But at the same time, I do think it's a very powerful tool. I think if you use the right prompts, you can get some pretty good results out of it.
Yeah, that makes sense. And I would say, like Vincent says here, I think that at the very least, right, it's hey, maybe it generates a first draft, gives you some ideation. You should always, always, always have that reviewed by a law firm professional lawyer. I mean, it's just too important, right? And as we know, as probably all the listeners know, and definitely Vincent, it hallucinates, right? It might miss something, it hallucinates, it does all kinds of things. And I remember one of the early episodes that Rico and I did, there was a lawyer who got in a lot of trouble because he cited a case that didn't actually happen. And of course he said, is this a real case to ChatGPT? And it said, yeah, this is a real case. so So he blindly
Yeah, well,
believed.
exactly. So
Yeah.
the judge in that case, and there were actually several case citations, and the problem that the attorney ran into is, he used it. He didn't check the work to make sure that the cases were actually good cases, and it turned out that GPT just made up the cases. They weren't even
Right.
real cases, but they looked real because they were cited the way that legal cases are cited in briefs.
Yeah.
But it came up in front of the judge, and the judge, asked him, did he check these cases? And he's like, yes, I checked those cases. Well, he got himself sanctioned because they found out that the cases were not real,
Wow.
and that he had used Chat GPT and then lied to the judge about it.
Yeah, that's yeah, so I mean that's the thing, right? Like from the start, we've been informing folks like, hey, don't ever blindly, even if it's not a legal document, right? Even if it's just, research for school or whatever it is, you need to be verifying these things, right? And there's a nomenclature called 10-80-10, which is 10, you're setting the vision, you're getting an initial prompt set up, then 80%, right? Like let ChatGPT or whatever tool you're using do some work for you. But then that last 10%, right? That's where you're scrutinizing. You need to really be sure that it's the right stuff. And sometimes it's back to square one because it's very, as you know, Vincent, it's very iterative, right? Like getting the right answer out of these tools the first time can happen, but I'd say it's a very low percent. So folks out there, make sure you're iterating, make sure you're checking and scrutinizing. And that case was really interesting. And I'm sure since then, right, I'm sure you probably don't hear about him as much because that was like the first time I think it was really like everybody was like, oh, there's probably been a lot of that. So I'm sure he's not the only one who's ever done that, right? So
Well, I haven't heard of another case where they miscited
okay,
cases, but I think because the reason being is he probably used it and didn't realize that ChatGPT hallucinates. But once that
right.
case came out and all the attorneys found out about it, they're being cautious about it, how they're using it. And also, even some of the judges are placing restrictions on briefing and having attorneys sign a certification that they either didn't use Chat GPT or they did use it and they've checked everything. So yeah, and that was actually Judge Starr here in the Northern District of Texas did that. And there's
Cool.
been some others who've implemented some local rules for that purpose as well.
Yeah, no, that's good. I mean, like it's like fool me once type stuff, right? So as far as let's kind of dig into intellectual property law, right, and AI, and can you give us just some idea of IP law in general and like some of the nuances there, and then really how AI, the as you said, it's not a new thing, right? AI is not new, but I think let's call it modern AI, like LLMs, is definitely newer. And just kind of give the listeners an idea of some of the stuff that would fall into that realm of intellectual property, and then fall into the realm of intellectual property specifically around AI creations and inventions.
Sure. So, there's several aspects or issues, I should say, that come up with respect to intellectual property and artificial intelligence. One of the issues is, can you protect the inventions or the works that are created using a tool like ChatGPT or Midjourney, whatever it might be? Are you able to protect that? And the Copyright Office and the Patent Office, both, in my opinion, are probably a little more cynical, I guess, of allowing protection for works that are generated by Gen AI or inventions that are created using Gen AI. So let's talk about patents in particular. Patents, in order to be an inventor, You have to conceive an idea, and you can't be an inventor if you're a machine or if you're an animal and you're not a person. The law is pretty clear that you need to be a person in order to be an inventor. However, what the patent office has said is you can use Gen AI tools or other AI tools to assist you in creating inventions as long as you have a substantial contribution to the actual creative or conception of that invention. If you didn't conceive the idea and you just watch Gen AI produce it for you without any input, then you're not an inventor. So compare that, though, to the case where the inventor of the microwave oven, for example, he discovered it by pure accident. He had a candy bar in his pocket while he was testing out microwave transmissions from a magnetron, and he discovered that his candy bar was melting.
Wow.
And when he discovered that, he put some other food. He saw that popcorn would pop when he, put it in these microwaves. And so that's how the microwave oven was invented. It was an accident. Now, he accidentally discovered it, but he did appreciate the fact that he had just discovered a really clever invention.
Yeah.
And so he ultimately obtained a patent on the microwave oven. But again, he's an accidental inventor. So how is he different? My question is, how is he different than the inventor who uses AI and accidentally discovers an output from AI that also is patentable? I think that the patent office is probably a little too restrictive in requiring that substantial contribution to the conception of the idea. And so then the next issue is with regard to copyright law. Under copyright law, you have to be an author of the work that is being generated. And the Copyright Office says if it's only Gen AI that is producing an output and you make no changes to that output, then you're not an author. You can't get copyright protection. It doesn't matter what kind of prompts you use to generate that work. According to the Copyright Office, their opinion is that, well, you don't really choose how Gen AI expresses that idea. Gen AI does that by itself. And so I think that's problematic too, because what's the difference between Gen AI and, putting a prompt in and getting an output out? What's the difference between that and somebody taking a picture using a camera? They didn't actually make that picture or form that film or negative.
Right.
The camera did, and they just simply pushed the button. Now, obviously, photographs are copyrightable. There was a Supreme Court case that it said that you can get copyright protection, but just like Gen AI now, back then there were people who didn't want protection for photographs because they didn't view it as a really creative avenue of expression. And so therefore, the painters and they didn't want photographs to be protected because they felt like it was going to take away the market for their works, their paintings that they did, portraits, of people would no longer be needed because people can just, use this cheap, easy photographer to take a picture of them.
Wow. When was that? Because I don't know. I don't have a point of reference for around what, how long ago was that type of, the camera was invented, and was that, I don't have a good point of reference. You probably know, but I'm super interested in that now.
I think it was in the 1800s. I can't remember the exact year of that, but I would have to get that information and
No,
get back to you. I don't have that in front of me right now.
No, that's fine. It's the same idea for a bunch of different things, right? Like one of the stories that I heard that was kind of interesting was, like if you look at the different things, like Photoshop, right? I remember Photoshop, was like, oh man, graphic design, and people were like, oh, it's print is whatever, and this makes it too easy. And then think about this, right? Photoshop's plugins as well. They came out with those like Kai's power tools. It was like, oh, you're not a real Photoshopper. You're just using the plugins. So I do feel like this stuff ends up getting layered, especially in the artistic community. This stuff just it continues to get layered, and it always will, right? Like think about how we used to produce music 200 years ago and how we produce it now. It's a whole different thing, right? And it's based really on the capabilities, not necessarily of a person, but of technology in general. What capabilities are out there? Oh, well, if you can do this, then why would you do that type thing? It's sort of like doing, math on a piece of paper, which I think is important to some degree. But then there was a point where the calculator came out, and there's not a reason to do that. Like, all right, now we've got to do every piece of math, right, on a piece of paper longhand. So that's brought us up to like, okay, let's think about higher level things and more relational things and whatever it is, right? So that's kind of my take on it.
Yeah, I agree with that. I think that one example of a case that I think the Copyright Office got it wrong is the Vincent Allen case. And that case is, it's not just a case of putting one prompt in or one question, give me an image of an opera singer, right? That's not what he did.
Right.
He took, I think it was 764 prompts that he used. He had this vision in his head about an image that he wanted to create, and he kept iterating. And that's what artists do. They iterate until they get something that they're comfortable with, that they like, that represents the vision that they were trying to express. And so that's what he did. 624 times, he'd get 4 images from each one. He picked the one that he liked the best and then continue with that one. And then at the end of it, he used Adobe as well as a resolution improvement tool, and he made some changes to it to get the end product. And then he submitted that to the Colorado State Fair and actually won his category. Yeah. But then they found out that he used Midjourney to create the image, and they didn't like that. So they created a new category and had some rules that required disclosure of the use of Gen AI before you submit it. But in the meantime, he filed a copyright application, but the Copyright Office refused to grant him a copyright on the entire work. They said he had to disclaim the work that was generated by Gen AI. They would give him a copyright in the changes that he made, but he wasn't happy with that. He wanted to be able to protect it all.
Yeah.
And so he filed a suit in Denver District Court to appeal that decision by the Copyright Office, and that's pending there now.
Okay. Yeah. And one of the things now there's now kind of a trend, right, in what we're talking about, which is businesses and really pretty much anybody right now has to adjust how they operate based on AI technology and the differences, right? We talked about law, right? There have to be specific rules put in place and a framework put in place to disclose, right? That's a big one. And then similar to this artwork thing, right? Like it's, you talked about, hey, he won the competition, then they found it out, then they said, well, let's have another category. Now, I don't necessarily agree or disagree with that. I probably come on the side of disagreeance, to be honest. But, it's something that was adjusted based on a new finding, right? Which is that AI art can win contests. I think there was another one, right? Like a Sony art fest or something where they, the guy who submitted it, it was a digital piece of art that was also generated by ChatGPT or not, probably not ChatGPT, but something like Midjourney, right? And he won that, and then he, of course, he said, "Oh yeah, that was AI or whatever," and then people freaked out. So,
Mm-hmm.
so yeah, I think the world is definitely adjusting and changing all the time, and we're only going to see more of that, right, as we come into future years here.
Yeah, I agree. And I think, a lot of it is, people are afraid or have fear, of the unknown. And so they're not really sure, how AI should be treated. Similar to the camera. By the way, that case was an 1884
Okay.
decision by the Supreme Court of the United States.
Wow.
It was a photograph of Oscar Wilde, and anyway, he
Wow.
prevailed. But it's similar situation at that time. There was a lot of uncertainty about whether this should be protected or not. But
Yeah.
ultimately, the Supreme Court found that there was a creative expression, and I think similarly here, the courts are likely to find that even the use of prompts to create something using Gen AI is enough to rise to that level of creativity. The interesting thing is that the Copyright Office says, well, you can get copyright protection in your prompts. Well, that's not necessarily what I want. I mean, maybe I
Right.
do want it, but I want to be able to protect my resulting work.
Yes.
Because if I can't protect it, then that means anybody can copy it, right? And so I think you have to kind of balance that. Are you going to reward, creation of different works using Gen AI? Does it really matter that it's a new tool that's been developed that's, pretty well advanced, but
Right.
it's not all that different than using Adobe Photoshop, that
Yeah.
in fact, Adobe now has some AI tools
They do.
in
Yeah.
it as well.
Yeah.
Yeah.
No, absolutely. So, one of the things that I also wanted to kind of chat with you about, because our listeners, a lot of them are in the business world. We have a lot of, CEOs, founders, and, they're running a business, and they know that, there may be rogue AI being used, not maliciously, right? But they just have no idea, what's going into these and different stuff like that. So can we talk a little bit about, you kind of alluded to it in the beginning of the show, right? That compliance and some of those considerations for, common, like PII is a big thing and stuff like that. Can you kind of talk to some of the tips you would give businesses in general as, as the advent of LLMs and other tools become just available to anybody and people know about them?
Sure. Yeah. So, there's two different ways you can look at AI. One being from the development perspective. Am I a startup or a business who's developing some new technology that uses AI? And if so, how do I make sure that I produce the best product that I can that's not going to get me sued later in litigation by my customers or their customers? So that's one aspect that we can look at is, actually how do you develop it in a responsible manner so that you get good results out of it, so that it doesn't have bias, and so that you're not going to have these claims. How do you oversee that product and make sure that it's acting like it's supposed to be acting,
Yeah.
and not going rogue, right? And then the other approach or consideration is, well, what if I'm just a business who wants to use AI technology? I'm not developing it, but I want to use somebody else's software. It's been said, well, maybe you just need to get an indemnity provision and get the software developer that provides you with the software to indemnify you for any bad results. Well, that's a good idea, but it doesn't absolve you from liability if you choose a product that's not really good for what you're asking it to do. So what are some of the things that can come into play? And, it all depends on the use case, how you're using it. Some uses of Gen AI are, much higher risk compared to others. And so you have to take that into consideration. But obviously, one of the things you mentioned was the PII and, the security of the data that you're putting into the model. You have to make sure that you've got it structured in a way that's going to protect that you have permission to use whatever data you're using, and that you've got the agreements in place for that, and that you're securing it, behind the firewall, or, it's not getting out to train one of the large language models so that it would inadvertently be disclosed to someone else. So you have to worry about those sort of considerations as well. But then again, I'm the one using the model, so I need to make sure it worked for what I want it to work for. I need to make sure that it has the proper disclaimers in place, depending on whatever regulations might be applicable to that situation. So does it have the consents required for your customers to sign when they use it, that they acknowledge that this information is being used to process, or being used at a third party to process their data and give whatever output you're asking it to give. So the consumer needs to be made aware, because if you don't make them aware, then you may be subject to lawsuits. And one such lawsuit is the Patagonia case. And in that case, Patagonia was using a third party to listen in on customer phone calls and process the data from the call using AI, and then give some recommendations to the customer service representative based on that. Well, there's been a class action lawsuit filed claiming that Patagonia didn't give the appropriate notices that their data was being used by AI. They simply stated that the typical statement that your call may be recorded for quality assurance purposes. But the class action saying, well, that wasn't sufficient. So those are some of the things that, you might need to take into consideration. But again, it depends on your particular use case. And if it's a higher risk use case like HR and employment, where you're making employment decisions, or you're giving employees information about their benefits, that kind of thing, then you definitely need to put a closer eye on how that works, and also provide the oversight necessary. Do you need a human in the loop, for example, to check the result that you get out of it?
Yeah, absolutely. Now, with that Patagonia case, is that still ongoing, or did they actually, was there a ruling in that one?
I don't think there's been any final determination in the Patagonia case, so it's still pending as far as I'm aware.
Yeah, that's really an interesting one, because I know a lot of businesses, I'd say pretty much every business, right, has that your call may be recorded. But having those additional terms, right, and consents from people. I'm in the communications industry, and that's a huge thing, right? The technology that we're spinning up, right, it all has that consent, the trust built in. There's a real implication, right, of getting that wrong. So tell me a little bit about what you and your business do, because I believe you actually can help businesses with that.
Sure, yeah. As I mentioned, my colleague Rob Taylor has vetted many different use cases for a large Fortune 50 company, but over the course of, I think he's over 200 cases now. But essentially, what we do is we look at how the model or how the system works, the software, look under the hood, look at the prompts that are being used so that we can ask questions about, well, why are you using this particular prompt? Isn't that likely to give you an erroneous output or something that might be biased, for example? And so we do that kind of thing. We also look at, the model that's being used and the terms and conditions associated with that particular model. So, for example, we would tell you to never use DeepSeek because of the risk that your data gets shared with the Chinese government. But you do need the terms and conditions of different models are different. So some of them require you to indemnify the model owner for any liability that results. And others say, okay, well, we will indemnify you, for example, for any intellectual property infringement claims that arise. Because there's this whole another set of lawsuits involving fair use and whether it's proper to use your copyrighted materials without permission to train a model. So OpenAI is pursuing that, and we're going to find out whether that's permissible or not. But so that's just one example of something you may want to look at. And then, of course, the contractual terms with your vendors, making sure that those are appropriate whenever you are developing or they're helping you to develop an AI solution, knowing who's going to be responsible for what, because again, everybody can ultimately be held liable in a lawsuit. The developer can be held liable. The user of the software can be liable because they're the ones that chose it. It's no different than saying, okay, I'm going to hire this employee for my company to handle HR, and then that person, makes a biased hiring decision, and now you're accused of discrimination because that employee worked on your behalf. Well, it's no different to use software to work on your behalf than it is to have an employee to work on your behalf. So you have potential liability there as a company that you need to make sure you protect against.
No, absolutely. So as we start to wind down here, Vincent, a couple of things. One is any other tips for business owners to make sure that their business is protected as they start to use AI and their people start to use AI?
Well, so one of the common ways that AI is used is to generate content, whether it be text or artwork. And what I would say, at least under the current state of the law, I would recommend that you make changes to that so that you will have copyright protection in the resulting work, that as long as you're adding some level of creativity to the document by, revising the wording of the text or revising the look of the image that has been created. So if you can do that, then that'll help you get copyright protection. If you're actually developing software, and even if you're using a large language model off the shelf, keep in mind that you may be able to get patent protection on that particular application that you've developed if you think it's new and non-obvious in view of the prior art. And then, of course, making sure you have the appropriate policies in place within the company to protect yourself. Make sure everybody knows that they can't just put all this information into the free version of ChatGPT. And that kind of thing. Don't assume that everybody knows as much as we do, that we're in it every day. Not everybody has that same experience.
Yeah, that's right. That's the first thing when I really took up the AI had at Clarity, and like, I've got to figure this stuff out and make sure we're using and adopting it both efficiently but like responsibly too. Literally the first thing that I did is I formed a committee. I called the AI Ambassador Group, and we built out the policies. One of our directors called it the do not do list, right? Like those different things. And then it's not good enough to just have it somewhere in your knowledge base or your handbook. We do trainings, like very frequent trainings, like out in the open with the whole company. Here's what PII looks like. It's not just social security numbers. It's other sets of data that can be used to identify somebody, right? So yeah, it's super important. That one I think is like a 100 level. Like every company needs to have at least an AI policy in place. And so yeah, no, that's a great one. And yeah, so Vincent, how can people get a hold of you? Because I would say that there will be listeners that are interested in, especially I think that side of building a software product and really understanding and having from a legal level, right, an advisor to go through and the prompt, reviewing the prompts. That's one of the coolest things I've heard in a long time, honestly. So how can folks get a hold of you and your firm to help with that?
Sure. My phone number is 972-367-2001, and my email is Allen, ALLEN, at CAGLAW, CAGLAW.com, and you can also find our website at caglaw.com, and you can read more about the AI Triage Center at aitriagecenter.com.
Oh, awesome. So you guys actually have a site spun up for that. I'm going to go check that out myself after the show here. And folks, we will have those that information to get a hold of Vincent here in the show notes. And yeah, Vincent, I just want to thank you for being on the show. Really glad we got together.
Yeah, so I certainly appreciate the opportunity to talk, Mike. I really enjoyed it. You have a great way about, asking questions, and I think we get a lot of good here today.
Yeah, absolutely, Vincent. So folks, check out Vincent's site, especially if you're building software products, as I know a lot of the people in the community are. It's super important to be broaching these and not just skimming over the the bias. It's not a big deal or whatever. Prompts have a lot of power in them, and they need to be structured correctly, especially if you're going to then bring that out to other people. And yeah, so that's it for this episode, folks. And we'll see you back in the lab soon. Thanks, Vincent.
See you, Mike.
Thanks for joining us. Don't forget to like, subscribe, and let us know your thoughts in the comments. Stay connected with us on Twitter, Instagram, and LinkedIn for all the latest updates. And check out antics.tv or our YouTube channel at Artificial Antics. We'll see you back in the lab soon.